This is a video from my professional responsibility class about conflicts of interest. And in this video, we're talking about the comments to Rule 1.7 that pertain to material limitation conflicts. And so remember, in another video, we talked about directly adverse conflicts where basically, and I've said this before, if your clients have a situation, you have two clients, and helping one of them hurts the other, we're usually going to frame that as they are directly adverse, and that's that type of conflict of interest. Material limitation conflicts, on the other hand, are where maybe your two clients, helping one doesn't hurt the other, or hurting one doesn't necessarily help the other, but for some reason one of them it can control your judgment, or you as the lawyer have an incentive because of one of them to not try hard enough or something with the other client. And so let's talk about this. This is material limitations in conflicts of interest under 1.7. And if you're going through the comments, we're on comment 8 to the rule. And just as a quick reminder to my law students, the MPRE tests the comments as if they are rules. And so you could have a question on the MPRE, actually a lot of questions, that are really based entirely on content or provisions that are in the comments to the model rules. It's very, very important for you as a law student to not just learn not only the rules, but also the comments. So comment 8, even where there is no direct adverseness, a conflict of interest exists if there's a significant risk that a lawyer's ability to consider, recommend, or carry out an appropriate course of action for the client will be materially limited as a result of the lawyer's responsibilities or other responsibilities or interests. Here's an example. For example, by the way, and when you're going through the comments, always flag or pay special attention to the examples, because those lend themselves so easily to being turned into multiple choice questions on my test or on the MPRE. So for example, a lawyer asked to represent several individuals seeking to form a joint venture is likely to be materially limited in the lawyer's ability to recommend or advocate all possible positions that each might take because of the lawyer's duty of loyalty to the others. The conflict in effect forecloses alternatives that would otherwise be available to the client. To go back to an illustration from an earlier lecture, let's say John, Paul, George, and Ringo come to you and they have a band and they're starting to have some success and they want to start their own record label, and they really all want to share a lawyer. Why? To save money, right? They want to save money. And so they come to you, and the problem is that even though they've overall worked out the deals, they want to share everything evenly and so forth, and maybe you can convince yourself that you'll be fair to each of them, there could be suggestions, things, if each of them had their own lawyer, that they might suggest that you're going to be afraid to bring up on behalf of one. So let's say it's John, Paul, George, and Ringo, and after hearing them play a few times or listening to their music and talking to each of them, you realize that two of these guys are the real talent in the band, right? They write all the great songs. They sing pretty good. They have the personality that kind of makes the band, and the other two guys don't quite aren't extroverts and so forth. So you realize that there's two of these guys have all kind of almost all the talent in the band. Well, if they had their own lawyers, somebody might suggest something like, okay, we're going to allocate things based on how talented people are or who writes the song. And in fact, with John and Paul, early on in their relationship in the Beatles, they didn't share everything. John and Paul agreed, because they were both really good at songwriting, that every song one of them wrote would be attributed to both of them. So if you're a Beatles fan and you have Beatles albums, all of the songs, most of the songs are just Lennon-McCartney songs, even though typically either John Lennon or Paul McCartney wrote the song, but they just headed off themselves ever fighting about songs, because they would both give the other one joint credit for every one of their songs. And that was actually pretty clever. It didn't keep them from breaking up after when they got really famous, and one of them got a girlfriend that couldn't get along with anybody else, and all of these things happened to them. But there are things that you as a lawyer might think about. And so another example would be talking about, okay, so let's put some provisions in here about how you're going to divide things up if one member of the band wants to quit and go pursue a solo career. And as you know, that happens lots of times with rock bands and so forth. And what's the deal? What is their deal with future royalties, or for the band's successes thereafter? Do they get a one-time check when they leave, or what happens? And the fact is, if they all had different lawyers, some things would get put on the table and negotiated about that you, when you're representing the whole group, are likely to skip or overlook. And that's what comment 8 is concerned about. Now, this sentence from comment 8 is almost I think of it as the heart of all the problems with conflicts of interest. The mere possibility of subsequent harm does not in itself require disclosure and consent, does not require disclosure and consent. And so in your mind, I want you to think about sort of a spectrum or continuum of conflicts. And in the middle, we have sort of the classic garden variety conflicts of interest that I've been talking about. You're representing co-plaintiffs in the lawsuit, co-defendants, the buyer and seller of a corporation, the husband and wife that want to you to draft their wills together jointly, and so forth. And these are kind of typical, and in a lot of these cases, in fact, they could consent and you could proceed with the representation. Then we're going to have an extreme conflicts where there's no way that we would consider them non-consentable conflicts, where they're just absolutely prohibited. We'll talk about that in depth in a future lecture. And the Model Rule 1.7 gives that one of those scenarios right off the bat. One non-consentable one is trying to be the plaintiff's lawyer and the defense lawyer in the same lawsuit, right? Or the prosecutor and the criminal defense attorney in the same criminal case, right? You can't represent both sides in the same lawsuit. I keep calling that the sitcom situation. That's the extreme conflict, and it doesn't matter. It doesn't matter if both clients say, we agree, we consent, we'll put it in writing and so forth. Even if with consent, the conflict is so extreme that you can't provide joint representation in that case. On the other end of the spectrum, we have the type of conflict that is so speculative or attenuated that actually would probably be fine for you not even to bring it up with the client, right? And so you could have situations where you have a client come to you, and so here's sort of my extreme, like, don't even bring it up situation. You represent a group of clients like Green Acre, Red Acre, Gold Acre, Gray Acre, Pink Acre, and so forth, all on unrelated matters. It's always conceivable that after you undertake the representation, that some unforeseen legal dispute will arise, right, between them. How do you know that Green Acre and Golden Acre aren't going to get in a fender bender at some point just by some bizarre coincidence? Like, stranger things have happened than getting in a fender bender or a shoving match or some sort of legal dispute with someone else who happens to use the same law firm. So even though that's a theoretical possibility, if there's no like specific foreseeable case that would give rise to that, then that's pretty speculative, right? That's probably too speculative, and you don't have to bring it up. Like in theory, any two clients could eventually have a dispute or could turn on each other. And then when it comes to material limitation, it could be the same thing. So we talked about the situation with business rivals don't count. Now, is it possible that at one point the rivalry between them could be become so intense that one of them is pressuring the lawyer to behave a certain way. Of course, that's possible, but the mere possibility of subsequent harm does not necessarily require disclosure and consent. Now, where's the line? There isn't one. There is not a clear line here, and that is why, in practice, these situations are so difficult, and why these situations give rise to such a disproportionate number of legal malpractice claims, because we have this kind of continuum, and right in the middle, it's kind of easy. We got to bring it up. We got to get consent. Way to the extreme, it's an easy call. Consent is never going to be good enough. It's non-consentable. And then way over here on the other extreme of the continuum, in theory, a law professor could have come up with a bizarre hypothetical of a conflict or potential future harm, but it's so unrealistic or so unlikely that we don't need to ask. But the problem is the boundaries between them are completely blurry, right? So therefore, you could get all the lawyers in your firm together to argue, can we take this client, can we take this case, and have 5 different opinions about whether there's a serious enough conflict. And so what do? You make a judgment call. And why does this come back to stab you in the back later or bite you in the future? Because in hindsight, when something does come up, it's always going to seem foreseeable, right? And so hindsight is 20/20. If subsequent harm does happen, we're going to look back and say, well, you probably could have predicted that, even though where you sit on the front end, you kind of couldn't. So here's questions. What's the likelihood that a difference of interest will eventuate? Secondly, if it does, whether it will materially interfere with the lawyer's independent professional judgment in considering alternatives or foreclose courses of action that reasonably should be pursued on behalf of a client, and so forth. And so here's a couple examples from cases. One is from the DC Circuit. A conflict materially limited a lawyer's representation of a couple in estate planning when the lawyer knew at the time the wills were drafted that the husband, unbeknownst to the wife, was actually married to another person. This is kind of a humorous example, and there's actually another famous case of that's in some of the professional responsibility lectures and books of a husband and wife. And again, I've mentioned this before. A lot of people go and middle-class Americans get their wills done when they're middle-aged, right? And a lot of times what kind of prompts it is one of their elderly parents has passed, and they've kind of realized what a nightmare it is to go through probate when there was no will. And so they decide, well, let's say we're in our 40s or we're in our 50s or 60s, it's time for us to get a will. And for a lot of middle-class Americans, they have one big asset, which is their home. They have some debts. They have a couple of used cars and a little bit of retirement savings, but it's not a complicated estate. And so lots of lawyers will do joint wills for spouses, where they're just saying they want to leave everything to the other one if they go first. And if they both go together, they're leaving it to the heirs or to their favorite charity and so forth. So I want you to imagine a situation, because this has happened, where the husband and wife come in, you figure no problem, pretty straightforward. If one of you dies, the other one gets to keep the house and everything, and so forth, straightforward. Then the husband calls you the next day and says, there's something I think maybe you should know about as my lawyer. I don't think it matters, but I've never told my wife this. I had an affair one time, and there's a child that resulted. I've never met the child. I haven't been involved in her life. She's probably about 20 or 21 by now, and so forth. But I just thought you as a lawyer should know that. So this has happened, and now you have a problem, right? So first of all, is the fact that there's a living heir relevant to the estate planning? Absolutely. Could this have consequences if that husband dies and somebody else has a legitimate claim on the estate? They were an out of wedlock child that the spouse never knew about. And on the other hand, you have a duty of confidentiality to them, but you also have a duty to disclose it to the spouse. Or you have, as in re Shea from DC, you have the person who comes to you and says that they're married, that they actually have another wife someplace. in my years of involvement in churches, I've come across this twice. I've had people come to me who, and it was both situations, they had gotten married very young. It was the men who were talking to me about this. A guy who had married young, didn't work out. The spouse, the wife left him after a year, and he wasn't very grown up at the time, and so the spouse said, well, he said, do I have to do anything to get a divorce? And they said, no, we'll take care of it. And so he just never thought about it. And then a decade later, he has his life together and meets someone and gets married, and then starts remembering, I wonder if I ever really finalized things. And it turns out that the divorce from the other person was never finalized. And so this does happen to people. It's a rare situation, but now you as a lawyer have a problem, and you are not going to be able to continue with the representation, probably because it's very relevant to estate planning, and now their interests are divergent, and it can be a problem if one of the spouses is telling you secrets not to tell the other. If you are doing estate planning and wills for married couples, I would recommend that during the consultation you explain up front, if you tell me any of your deep dark secrets, I won't be able to keep it from the other, from your spouse. So if you have something you've always kept from this person, like a child that you sired out of wedlock, or somebody else that you're married, technically still married to, or something like that, then if you tell me, I'm going to have to either tell the person, or I will have to stop representing you mysteriously. And so next, there was an example from Louisiana in 2000. Let's say an assistant district attorney representing a husband in a divorce case should have withdrawn after the client's wife, his client's wife, filed a criminal complaint against the husband. And so he's representing one person in a divorce, but he also, in some small towns, you have private firm lawyers who also kind of do contract work as the prosecutor, district attorney for a certain town. And so now all of a sudden he's supposed to be prosecuting his own client, and that is a conflict of interest. That ends our lecture on material limitations.